Good afternoon, everyone, and welcome to today's webinar, California Assembly Bill 5 and the Travel Agent Services Exemption, What You Need to Know. My name is Cara Kurtz, and I am the Coordinator of Business Development of ASTA, joined by Genevieve Strand, Director of Advocacy here at ASTA, and we will be the organizers for today's presentation. We're very happy to welcome today's presenter, our very own Peter Labasso, General Counsel of ASTA, the American Society of Travel Advisors. Before we get started, I'd like to point out a few important features on your screen that will allow you to interact with us via the web. We'll be answering your questions at the end of this presentation. To ask a question, you will be using your GoToWebinar pane. Near the bottom of this pane, there is an area that says questions. If you click the arrow next to where it says questions, it will open up a window pane, and this is what you'll be using to communicate with us today. If you're having trouble hearing this presentation, please make sure that your speakers are turned all the way up. And if you've called in, please try hanging up and dialing back in again to rectify the problem. You can send me any technical issues via the questions pane, and I will try to answer them via the same pane to the best of my ability. Please also note, in this pane, there is an area labeled Handouts. Here is where you can find a PDF copy of today's presentation. Please also note that though we want to hear from all of our audience members, you all are muted. We certainly want to get everyone's feedback, but background noise would prove to be prohibited, and we want to ensure that everyone can hear the entire presentation. Finally, please remember that this webinar is being recorded and will be available for your on-demand viewing pleasures for all ASTA members at asta.org by early next week. Now, without further ado, it is my pleasure to introduce my colleague, Peter.
Thank you, Cara, and welcome to all of you out there who are joining me today. By now, I suspect everyone has heard about California Assembly Bill 5 and the great victory that ASTA won in securing an exemption for travel advisors. But that being said, if you engage independent contractors in the state or are engaged as one, there are a few things that you will need to know to ensure that you'll be ready when the law goes into effect in January. Let me briefly run down what we will discuss this afternoon. I'll begin with a brief review of the California Supreme Court's decision in the Dynamex case, which applied the ABC test that was later incorporated into Assembly Bill 5. Then we'll look at what would have happened if ASTA had not gotten an industry exemption. But of course we did, so we'll quickly review how we got there. And then I'll walk you through the criteria your engagement must now satisfy to operate under the professional services exemption. And with the remaining time, I will be happy to take whatever questions you may have. So let's get started. To understand how AB 5 came to be, we first need to examine what the California Supreme Court did in April 2018 in the Dynamex case. Dynamex involved two delivery drivers who sued the company that engaged them as independent contractors. The drivers' claim, in essence, was that they were really employees, and as such, they should have received overtime pay, reimbursement for their business expenses, and other employee-only benefits from the company that engaged them, none of which they received by virtue of their status as ICs. In order to determine whether the drivers were indeed entitled to receive all of those things, the court first had to decide what standard should be used when determining the status of the drivers. The court held that the determination as to a worker's status is to be made using the so-called ABC test rather than the common law right of control test, as had previously been the standard in California. In doing so, the court essentially overturned the holding in an earlier Supreme Court case known as the Borello Decision, which, among other things, held that a multitude of factors should be evaluated when determining a worker's status. I'll have more about that test shortly. Now, while the Dynamex decision was very disruptive in its own right, by the end of 2018, the California Assembly had already decided take things a step further, and the result was the introduction of Assembly Bill 5. AB 5 codified the holding in the Dynamex decision, specifically mandating that the stringent ABC test be used to determine the status of a worker as either an employee or an independent contractor in the state. Now, writing it into statute meant that the ABC test would be applied to workers in every industry unless a specific exemption could be obtained. And because Dynamex on its face only applied with respect to certain types of claims, AB 5 greatly expanded the impact of the Dynamex decision. So what exactly is the ABC test? As you can see, it's a three-part test, and in order for the worker to be considered an IC, all three elements must be satisfied. Namely, the worker must be free from the engaging party's control in the performance of the work. The work performed must be outside the engaging party's usual course of business, and the worker must be customarily engaged in an independently established business. Now, the A and C elements of the test are generally not difficult to satisfy. However, the B element of the test in California requires that the worker be engaged to perform a different kind of work as that of the business that is engaging them. Again, note that all three elements must be satisfied. 2 out of 3 is not sufficient, and the worker will, in that case, be deemed an employee. Now, what would applying the ABC test to travel advisors in our industry have meant? Well, a travel agency engaging an advisor to sell travel will most likely fail the B element of the test. And that's because the advisor would not be performing work outside of the engaging party's usual course of business. And because, again, all three elements must be satisfied, that type of engagement will, by extension, fail the entire ABC test. This, in turn, would mean that those IC relationships in California could not continue, and the advisors would have to be hired by the agencies as W-2 employees if they wanted to continue selling travel. Given that there are about 20,000 ICs in our industry in California, this would have been seriously disruptive, no matter what the affected people and the affected agencies decided to do. Agencies inclined to convert their independent contractors to W-2 employee status would face significantly higher payroll costs. That being said, most ICs wanted to continue operating as independent business owners, and for that reason, they're not simply interested in becoming agency employees at all. We know this because ASTA surveyed its membership, and specifically, 62% of travel advisors in California, that's about 5 out of every 8, told us that they would either leave the industry or the state altogether if they weren't permitted to continue doing business as independent travel advisors. Given the gravity of the threat to the IC business model in California, ASTA sprang into action, and with support from its consortia, host, and supplier partners, set an unprecedented grassroots campaign into motion. Our serious efforts began in July when ASTA staff and 2 members of our board of directors flew out to Sacramento to personally visit all 40 state Senate offices. After meeting with a key labor committee staffer, we drafted proposed language for inclusion in the bill. All the while, our members engaged with their representatives in unprecedented numbers through phone calls and emails. We also held webinars to educate our members and consortia partners about the impact AB 5 would have if it were not amended and also to keep them informed as to the next steps in our continuing advocacy efforts. As the bill passed out of the Labor Committee in mid-July without a travel advisor exemption, we redoubled our efforts in August, holding in-person meetings in state senators' home districts while the Senate was in recess. Along with our allies on the CCTO, the California Coalition of Travel Organizations, we then organized an impressive turnout 2 more times back in Sacramento later in the month, while a vote of the Appropriations Committee on further amendments to the bill was pending. ASTA supplier partners also got involved, and we received letters in support of our position urging an industry exemption from 15 major suppliers. All of that hard work finally paid off when on August the 30th, the bill passing out of the Appropriations Committee was indeed amended to exempt travel advisors. Specifically, travel agent services was added to the professional services exemption that already appeared in the bill. The Senate amendments to AB 5 were quickly ratified by the Assembly, and the bill then went to the governor's desk shortly thereafter. He signed AB 5 into law on September the 18th. The law, with the all-important exemption for our industry, goes into effect on January 1st, just 29 days from now. So the system worked. The legislators heard us, and we secured an exemption to spare our industry from the harshest effects of the law. So now that AB 5 has been signed into law with the exemption we requested, do agencies need to do anything differently starting on January the 1st? Well, because we were able to secure the inclusion of travel agent services within the professional services exemption, this means that the earlier Borello Standard, rather than the onerous ABC test, will be applied to workers in our industry, provided, however, that they satisfy all of the statutory criteria. And I'll walk through that with you in just a minute. But for now, what this means is that the traditional common law right of control analysis that was in place for about 30 years prior to the Dynamex decision will once again be used when evaluating relationships in our industry. And that's very welcome news, because the right to control test is more flexible and therefore much less difficult to satisfy as compared with the rigid and mechanical ABC test. Now, what about that statutory criteria? There are a total of 7 criteria that must be satisfied for a travel advisor's engagement to qualify for the exemption from the ABC test. The first 6 of these are common to all 11 categories of professional services in the bill, of which travel advisors are one. So let's start with those. The first of these is the requirement that the worker, quote, maintain a business location separate from that of the hiring entity. Now, by its own terms, the statute allows this separate location to include the individual's residence. That's important because home-based independent contractors can satisfy this requirement. I should note, though, that the statute also permits the IC to render services at the engaging party's business location, so long as the IC actually maintains a separate location of his or her own. Now, to avoid any doubt as to whether this first requirement is satisfied, my recommendation is that you look at the party's independent contractor agreement to ensure that it expressly states that the advisor's address is in fact his or her place of business. Second, the worker in question must possess a business license in addition to any other licensure or permitting that may be required in any particular circumstance. Now, business licensing is normally done at the local level, and this is unlikely to pose any real difficulty for anyone who's actually acting as a bona fide independent business entity. Now, the third and fourth criteria of the professional services exemption are listed here. The worker must have the right to negotiate his or her own rates and set his or her own work hours. Again, both of these are standard when engaging an independent contractor as opposed to engaging an employee, where you would set the work hours. So neither of these should create any difficulty, once again, if the relationship is in fact a bona fide independent contractor relationship, as it is most commonly understood. So far, so good. Now for the last two, and unfortunately these are slightly more complicated, particularly with respect to number 5. This one provides that the individual must be engaged in the same type of work performed under contract with another hiring entity, or hold themselves out to other potential customers as available to perform the same type of work. Now, this sounds all quite confusing, and I would certainly agree, because that was the take that I had on it when I first read it. So what on earth does that mean? What it's saying is that the worker must either render services to more than one entity, in our case, more than one agency or host agency, or alternatively, make him or herself available to be engaged by more than one. So taken together, this suggests that including an exclusivity clause in your independent contractor agreement is not advisable if you want the benefit of the exemption. Now, granted, the language used is not exactly a model of clarity, but that being said, prohibiting an exclusive relationship with the engaged party is definitely in keeping with the legislature's purpose and intent as far as setting the scope of the ABC exemption is concerned. Again, keep in mind that as a true independent business, the independent contractor should have the right to render services to whomever he or she wishes. And that again is why exclusivity is typically viewed as a problem in an independent contractor engagement relationship. Now finally, the sixth requirement is that the worker be customarily and regularly exercising discretion and independent judgment in the performance of the services. Now, what this is essentially saying is that the independent contractor, rather than the engaging party, controls the manner in which the work is to be performed. This, too, should not be problematic in most cases, as again, this is essentially a restatement of one of the fundamental tenets of the engagement of an independent contractor. So those were the 6 professional services criteria. But to be covered under the Borello Standard, the worker must also satisfy one more requirement, and that is to be in compliance with the California Seller of Travel Law. Fortunately, compliance can be accomplished in one of 2 ways, either by registering as a seller of travel or by qualifying for the exemption from the registration requirement. That's important to note because in many, but not all circumstances, travel advisors who are selling travel pursuant to a written contract with one agency or host agency that is itself registered as a seller of travel will qualify for the exemption. Now, assuming all 7 of the statutory criteria that we just discussed are satisfied, the engagement will be evaluated under the pre-Dynamex Borello Standard. While this means that an engagement that passed muster prior to the Dynamex decision should once again be okay next year, I thought it might be helpful to briefly explain the Borello Standard and how the courts have traditionally applied it. As noted previously, the Borello court used a common law right of control analysis to determine the status of the worker in question. When that common law analysis is used, the trier of fact, in this case the judge or the auditor who's hearing the case, will focus on to what extent the engaging party directs the contracted party's activities with respect to the questions of when, where, and how the contracted work is to be performed. Now, the general rule is that the greater the degree of control over the performance of the work that is exerted by the engaging party, which for our purposes is the host agency or the travel agency, the more likely it is that the relationship in question will be found to be employer-employee. Conversely, where the engaging party's control over the performance of the contracted work is either minimal or non-existent, that will support a finding that the worker is in fact an independent contractor. Practically speaking, the entire analysis under Borello is substantially the same as the analysis of only the A element of the ABC test taken by itself. So for that reason, you can see why Borello is much easier to satisfy as compared with the ABC test, in which there are 2 additional elements that must also be satisfied. Now, while the right to control the performance of the work, as we just discussed, is the primary and therefore the most significant consideration, the Borello court also set forth 8 secondary indicia relevant to a determination as to the nature of a given work relationship. These are known as the so-called Borello Factors. Let's very briefly look at each of these. First is distinct occupation. If the worker is deemed to be engaging in a distinct business, that is strongly suggestive of an IC relationship. 2 is supervision. If the engaging party's supervision is minimal or non-existent, again, that supports independent contractor status. Factor number 3 is the degree of skill required. As a general matter, where no special skill is required to perform the contracted work, that fact will support a conclusion that the worker is actually an employee as opposed to an independent contractor. Number 4 looks at who furnishes whatever tools or equipment is needed to perform the contracted work. Where the engaging party supplies all or most of that, especially at no cost to the worker, that will support an employer-employee relationship. Now moving on to the last 4 factors. The 5th element is length of time. A short engagement with a fixed termination date is usually suggestive of an independent contractor relationship, whereas a long-term relationship, especially one with an indefinite term, suggests just the opposite. Number 6, method of payment. Where a worker is paid by the hour, it typically suggests an employment relationship. Conversely, sales-based compensation, such as a commission, is indicative of an IC relationship. And on that note, I would like to add that that makes perfect sense if you think about it, because as an independent business, the IC is responsible for making sure that the time spent in the work is actually profitable. That's not the case for an employee, where the employer bears the risk that someone may work many hours without any sales to show for that. Moving on to number 7, we look at whether the work performed is an integral part of the engaging party's principal business. If so, that is generally indicative of an employment relationship. And finally, number 8, the party's belief with respect to the relationship that is being created. While labels used in an agreement do not by themselves establish the existence of an independent contractor relationship, the agreement's characterization is nonetheless relevant. But before moving on, I would like just to stress again that the analysis under the common law approach, which certainly includes consideration of all of these 8 Borello factors, is totality of the circumstances. And this means that we're not simply counting how many of the 8 factors are satisfied and comparing that against how many are not satisfied when making the determination. Note, too, that in some cases, one or more of the factors may not even be relevant to the analysis at all. So that is AB5 in a nutshell. But before moving on to take your questions, and I do hope you have many, I'd like to update you on what ASTA has been focused on since our big victory in California. First, we've spent a lot of time creating educational resources, such as this webinar, as well as a detailed white paper, a fact sheet to help you with your compliance. These resources are free to our members and will be available or are already available on asta.org. Separately, as many of you may already have heard, similar ABC bills targeted at ICs are being considered in other blue states, in particular New York, Oregon, Washington. While no formal action is expected on these bills until January, one thing we learned from the experience in California is the importance of being proactive and getting an early start ahead of the other industries that undoubtedly will also be lobbying to secure an exemption from an onerous ABC test. And of course, we'll need advocacy at the grassroots level among our members and our industry partners in order to accomplish that. But on that note, I am happy to report that our efforts in yet another blue state, New Jersey, appear to have already been successful, as their IC bill was recently amended to include a much more IC-friendly version of the ABC test than what was adopted in California. So given that, IC relationships in New Jersey will most likely continue to be evaluated under the test that is currently in place, which, although it is technically an ABC test, is a much more less onerous and easier to satisfy version of the test, because it allows contractors who maintain a separate place of business to satisfy the difficult B element of the ABC test. So that concludes my prepared remarks today, and at this point we've got about a half hour left, and I would be happy to take whatever questions that have been submitted to Cara. And we'll start going through those right now. But if I don't get to yours, or you think of something later on that you'd like to ask me about, please feel free to send me an email anytime, and I will do my best to respond as best as I possibly can. So thank you for that.
All right, everyone, before we jump into questions, I just want to remind everyone that this webinar has been recorded for all of our ASTA members, and it will be available online by next Monday. So by the beginning of next week, this webinar will be online, ready for everyone to view at their own viewing pleasure. Now, without further ado, Genevieve, you want to go ahead and jump into some questions?
Sure, thanks, Cara. So, Peter, we have a question from one of our members. Are they required to have a different business name from, sorry, apologies, I lost that question for a second. Do they need to have a different business name from the agency that they're with for their business license?
Yes, I would say so. If Blythe, if you are the IC in this scenario, if you haven't already formed a separate business entity, then you are being engaged as a sole proprietor. So your business license should reflect your name. By the same token, if you have formed a limited liability company or some other legal entity, then that ought to be reflected on the business license. Again, if you have a W-2 status, then none of that would be required, and certainly you wouldn't need a separate business license. So however you are operating, I would basically just take a look at whatever your IP contract reads. Who is the agency engaging? Are they engaging Blythe as an individual or as a limited liability company, et cetera? And the business license should match that.
Great. So in regards to the California seller of travel, if the host agency is registered as a California seller of travel, will that cover the IP and they would then not need to register as a seller of travel?
That's a really good question, and that's where I think a webinar like this is really helpful, because while AB5 was the big discussion point with respect to working in California this year, a couple years ago, California overhauled their seller of travel legislation, and it created some additional exceptions to the registration requirement. The short answer to the question is not every engagement with a registered seller of travel will satisfy the exemption requirements. What I would suggest doing, and I'd be happy to speak with any of you later if you have further follow-up questions, but I would refer you to the seller of travel fact sheet, which is available in the library on ASTA.org. It will walk you through each of the criteria to satisfy the exemption from the seller of travel registration requirement.
Perfect. Thank you, Peter. So we have another question here. If you work as a host agency and you have IC under that same company name, still working through the host agency, would you qualify for the exemption? As a note, they're all using the same IATA number.
It's a little ambiguous as written the question, just because I'm not sure whether you mean the exemption from the seller of travel requirement or the exemption from AB5.
I think probably the exemption from AB5. So if I work as a host agency and I have ICs under my company name, still working through the host agency, would that qualify for the exemption?
Yeah, that's a good question, and I think it would depend on a number of different circumstances. So, Mike, I see that you were the one who submitted that question. I'd be happy to talk with you a little more detail about that. It gets a little bit involved. I don't want to give anyone the impression that's an easy answer with a simple yes or no response. So I'd be happy to talk to you if you want to reach out to me.
So for that same question, Peter, would they be exempt for seller of travel purposes?
Yes, I think the short answer is yes, as long as they are all selling under the same seller of travel number. The IATA number is less significant for purposes of California than the California seller of travel registration number.
Great, thank you. So if a host agency is responsible to ensure that their ICs, is the host agency responsible for ensuring that their ICs have obtained that local business license? Is that something they should be asking for proof of?
Yeah, that is a really great question. And The short answer, the legal answer is no. It is not the responsibility of the host to ensure that they are in fact satisfying all of the criteria, namely the one regarding the business license. However, the engaging party is the one that is going to be penalized by the state of California should their IC relationships not pass muster. In other words, if your IC inadvertently does not satisfy the local business license requirement, they could be reclassified as an employee, which would then subject you to penalties, payroll taxes, etc. And certainly you don't want that. So what I would recommend, and what I think is a best practice for something like this, is to write something into your IC agreement that states that the IC will provide you with proof of compliance with the local business license requirement. That way you are not per se assuming responsibility for that, but if your IC is unable or unwilling to provide you with the proof, then you have the right to terminate your IC relationship on that basis, and that's a great way to limit your exposure to a reclassification audit.
Perfect. So we have a question about what if your host agency does not allow ICs to provide travel services for others? How would that affect your ability to get the exemption?
Yeah, that's a great question, and I've seen a number of variations on that when I've been presenting this material over the last couple of months. That is, strictly speaking, somewhat of a problem. It's not an absolute disqualifier under the common law of most states. In other words, there isn't a per se requirement that there not be exclusivity. However, in the context of the AB5 exemption, it is quite problematic. It relates to the fifth of the six criteria under professional services that we discussed. Again, the legislative intent is to look with much more skepticism toward exclusive relationships because, again, they look too much like employer-employee relationships. So my feeling is that if your host agency contractually bars you from providing travel service to any other entity, that would be something that would raise a bit of a red flag for me. There are certainly reasonable restrictions that can be placed on engaging with others, but a blanket prohibition would be problematic and would certainly, in my view, be fatal to claiming the AB5 exemption, meaning that relationship would then fall under the very strict ABC test, which, as we discussed, is going to be very difficult to satisfy.
Perfect. Thank you, Peter. So we have another question here. If an agency has an annual training retreat, that lasts 3 days, and ICs are strongly encouraged to attend, is that getting into gray territory in terms of the freedom of the IC?
Yeah, this is another really great question, so thank you for submitting that, Allison. The short answer is this is something that makes lawyers like me somewhat uncomfortable, to be totally honest, because we don't like to see the engaging party provide training because it undermines the whole idea that this is somebody who is operating as a separate business and is therefore competent to perform the contracted services without receiving any training. I mean, think about it. If you were a homeowner and you were looking to get somebody to install a new roof on your home, would you, as the homeowner, show him how to lay down the shingles? Absolutely not, because it would be silly in the context of engaging a professional to provide services. So, by the same token, we don't like to see training provided by the engaging party. Now, that being said, we know as a practical matter there are some difficulties which attend a blanket prohibition on that. So let me temper my response a little bit by saying that strongly encouraged is far better than mandatory. When you create a training regimen that is mandatory as a condition of the engagement, that's a big no-no in my view. What we look for and what I think is the best practice in the industry from the agency perspective is to simply have a recital in the contract that states that the independent contractor has the requisite skill needed in order to render the services, and leave it at that. If you want to provide some avenues by which they can obtain those requisite skills, that's fine, as long as you don't mandate your particular training over any other means by which they can obtain those skills.
Great, thank you. So a couple more questions, more related to the California seller travel number. If a host is out of state, would the host need a California seller travel number if that California IC already has one?
If the IC is in California and is already registered under the California seller of travel law, then there is no need for the host to have it. Now, in most cases, they will have it because they're hosting ICs all over the country. So that is a situation where, strictly speaking, no, they wouldn't need it. But in most cases, it's going to be just the opposite. It's not. The scenario you describe is not one that very frequently appears.
Great. So I guess kind of a similar question. In regards to errors and omissions insurance, would these ICs that are exempt still be able to fall under the errors and omissions insurance of their host agency? Yes.
The short answer is yes. There isn't any direct relationship under either AB5 or the California seller of travel law with respect to errors and omissions insurance. What I would say here separately is that the way I typically recommend that those things be handled is that if the IC is going to be covered under the host errors and omissions insurance, which is not an uncommon scenario, that the contract ought to recite that is being provided. And there may also be, although it's not required, some nominal consideration that is paid for extending that coverage to the IC. And the reason we would like to see that is because, again, it creates a greater distinction between the IC relationship and the employer-employee relationship, where no employee would ever be required by their employer to obtain errors and omissions insurance at their own expense. Again, that's something you would expect from an independent business, but not so much for an employer-employee relationship. So that's really the way I recommend that E&O be handled. Again, there isn't any clear connection between either AB5 or the California seller of travel regulation.
Perfect, thank you. So we've had one comment and a question in this regard for technical training on some of the back-end or booking systems. So if an IC needs technical training on their CRM or booking systems, some host agencies require that training to hire ICs. Would that change the requirements or the ability to get an exemption there?
Not really, but that certainly kind of goes to what I said before, that as a practical matter, sometimes drawing a very bright line and simply prohibiting any training is not realistic under the circumstances. Now, where there are specific technical skills that are needed with respect to the engagement by the agency, yes, it's understood, and that's something that everyone has to make a business decision about. Again, ideally there might be some other means by which that information could be shared with the IC. And that's the way I would try to approach it from a contractual point of view, to state that there is technical training that is needed for with respect to performing the work for the host in question. However, you might want to add some language that states that the training provided by the engaging party need not be taken if the IC can otherwise demonstrate the proficiency that's needed. So again, we're drawing a distinction between taking your training and having the skill. And I know it seems like it's kind of walking a bit of a fine line, and admittedly it is in certain circumstances, but again, you want to try to maintain that distinction as much as is realistic.
Great. So I think that that's all the questions we have at the moment. I guess last call for anyone on the phone. If you have any further questions, please do go ahead and submit those now.
All right, everyone, it doesn't look like any more questions are coming in. But again, this webinar will be available for all of our ASTA members on asta.org by early next week. It will probably be up by tomorrow. But I just want to go ahead and give our webmaster a little bit of leeway. So early next week, this webinar will be up in case anybody wants to rewatch or listen at their convenience. Thank you so much to Peter for another amazing webinar. And thank you to everyone for joining us today to learn a little bit more about California AB 5. All right, it looks like all we have is some amazing accolades coming in for Peter, thanking him. So thank you all as well. We really hope you have a great remainder of your afternoon.